Oh, yeah, we're not waiting for Tim. All right, we'll reconvene.
Oh, yeah, I got it.
Again, not doing well on my timekeeping today. Oh, yeah, thank you. Good afternoon. We're reconvening at 2:25. On this, is everybody here? I think a significant coterie of the people I expected to be here, I see here. So why don't we get started? Thank you for your patience. Darren, are you going to present? Or is Emel?
Emel's going to start for us.
I'll start. We're going to do it together.
Okay.
Okay. Good afternoon, board chair and board members. This is Emel Woodbani, Senior Staff Counsel. With me are Assistant Chief Counsel Philip Wiles and Deputy Director of the Division of Administrative Services, Darren Polhamus. I am going to start by very briefly explaining where we are in the process, but we will spend most of our introduction going over the most recent staff proposed changes. So very briefly, the proposed order before you resolves 5 petitions challenging a waiver of waste discharge requirements for agricultural discharges issued by the Central Coast Water Board on March 15th, 2012. Over the last few months, the State Water Board staff has issued 4 proposed drafts, June 6th, August 20th, September 9th, and most recently on last Friday, September 20th. The board has received written comments on the various versions of the proposed order in 3 comment periods and has heard oral comment on July 23rd and recently on September 10th. In the most recent comment period, we received a number of very helpful and productive comments from all the parties on the September 9th version that we had, the staff proposed September 9th version that we had released. And the September 20th version of the proposed order is aimed at acknowledging those comments and addressing them where we think it's appropriate. Today, you will be hearing oral comment on the proposed draft order, but before we turn to the presentations by the petitioners, Darren and I will give an overview of the most recent staff proposed changes. We will walk through the revisions on the screen up here. But there are extra copies in the back of the room if anyone in the audience doesn't have a copy. Again, what you see up on the screen is the September 20th proposed order, and these are just staff proposed revisions for addressing the comments. The September 9th version is actually in red, red line strikeout, and the changes made in the September 20th proposed revisions are in blue. These were distributed by email to all parties and interested persons on Friday, September 20th. Okay, the first, we're going to page 15. This is actually just a clarification. We made no revision here, but I think there was some confusion, so I wanted to explain this particular addition we had made in the September 9th version. We had a comment asking why we were stating that the cooperative receiving water monitoring programs were not subject to provision 11. Again, we haven't made a revision based on that because provision 11 allows third-party projects and programs not elsewhere specifically allowed in the order. It allows those to be proposed to the Central Coast Water Board, and then those would have a technical advisory committee review. Program proposals, such as the Cooperative Groundwater Monitoring Program proposals, are specifically allowed under a provision of the order and must comply with that provision rather than provision 11. Page 25. So we're now looking at, as soon as we get there, the water quality standards language, and specifically the new 87.5 that we added to the order. We're proposing one minor revision here to begin with that will state that dischargers must implement improved rather than modified practices if management practices have not been effective in preventing exceedances. This revision is made to make it clearer that additional practices implemented must improve on previously implemented practices in order to continue to move toward water quality standards compliance. You'll remember that we had a number of comments also asking for additional revisions to this provision. We suggested some discussion that went into our order language but wasn't going to go into the text of the Central Coast order. And we suggested that, and it's in red actually midway through the page. That was in the September 9th version, and we're continuing to keep that language, and it says essentially that it expresses that dischargers must make a conscientious effort in implementing these management practices, but that such efforts are expected to focus on known and available management practices in the short term. There's one other revision to the new 87.5, and that's that we're referencing provision 33 in that language now, and I'll talk about that a little bit more once we get to the containment structures. That's the provision on containment structures. In fact, containment structures is what we're doing next, so I'm going to scroll to that. There's 33. There has been, as you know, significant back and forth on the appropriate phrasing for this particular requirement, in particular whether the term avoid or the term minimize is the most appropriate. We have now proposed to retain the term avoid, but to clarify that what dischargers must avoid is the discharges of waste to groundwater and surface water that cause or contribute to exceedances of water quality standards. Additionally, by adding the reference to provision 33 into the new 87.5, we are proposing to clarify that the requirement to avoid these discharges will be achieved through iterative implementation of management practices. There are a number of specific practices listed in provision 33. We believe this is consistent with the way that the Central Coast Water Board has explained they would implement provision 33. The next set of edits, and these are probably the most extensive ones, are on the cooperative groundwater monitoring provisions. Darren's mostly going to talk about those. I will just premise it by saying that with the most recent revisions, we are attempting to strike a balance between the long-term benefits of characterizing the groundwater in the region and the near-term necessity of informing users if they are drinking nitrate-contaminated water. So that's the balance we're trying to strike here. And Darren can explain the specifics.
So we have not restored the monitoring for every drinking water well that was in the August 20th version, mostly because we believe that the wells that are projected that will either be below the MCL or above the MCL do not require verification of the actual level of nitrates with certainty. So basically we're saying, look, if you're way above or way below, the characterization's accurate enough, and we don't need to further clarify it for purposes of scientific endeavor, but it's good enough from a management standpoint, and it protects the drinking water component.
But people are informed.
Yes, certainly, yes, very, very, exactly. We would expect notification to occur for all those above, where water is characterized to be at 45 and greater, that they would be notified. And I would expect that we would also notify them of the anticipated amount that we're characterizing their well at, to give them that value judgment as well, just not that you're above, so that there would be information embedded in the level of answer. So what we've also done then is we have basically said that we would like the testing. So there was questions before about the level of certainty that needed to be expressed, and that got squishy on trying to define what a high level of certainty is, especially when the reality is that the certainty level that's appropriate for one area is unlikely appropriate for another area, and so it was this moving target. I mean, you could certainly default to a high level of certainty, but then you've spent money you shouldn't have spent in certain areas where there are very few drinking water wells and you just wanted to sample them anyways or something like that. So there was consequences of trying to set a very high level. And instead, we've, based on the comments we got, we have adjusted to say, if you remember before, we were recommending that wells between 36 and 45 receive testing. Well, by removing the high level of concentration, but then increase the protection, and in correspondence with some of the comments we got, we've modified it to say that for all of those waters that are characterized between 22.5 and 45, we believe that all of those wells need to be tested. So this requirement would say, test those wells. It then follows on to say that after those wells are tested, for those that have a testing result between 36 and 45, that they in essence need to be tested annually or at a different schedule if it's approved by the executive officer based on trending information. So in essence, we've eliminated the need by expanding our grasp of where people are going to get certainty numbers. And we think this comports with the expectation of the type of characterization that's being planned for within the region. Let's see, what's the other? Go ahead, cover it.
One thing that I wanted to mention quickly was that we do understand that there's some benefit to having certainty as to the level of nitrate in drinking water wells above the MCL. We do have comments on that. We recognize that. In particular, our understanding is that there are certain point of use devices that cannot be used after 120 milligrams per liter of nitrate concentration, and that having some certainty as to the level of nitrate will assist in a decision as to whether or not to use those devices. We appreciate the issue, but we believe that our priority right now is to provide an initial information to all users as to whether or not they should be drinking the water, and that resources beyond that should be used to achieve characterization of the aquifers in a manner that will allow long-term analysis of the groundwater and groundwater trends and assist us in managing those aquifers. So. And then Darren covered the technical aspects of the MCL and where we're expecting direct sampling and repeat sampling. One other thing that I'll point out is that another issue, obviously, beyond certainty, is the concern with delay in getting this information to users. We have tried to address the concerns expressed with delay by several sentences that we've added at the end in blue. These propose to require that the groundwater monitoring programs make drinking water evaluation a priority, that they provide notice of drinking water data as it becomes available, that we're not waiting until the end of the study to provide that information, and also that all drinking water evaluation requirements in this paragraph, except for the repeat sampling, which would happen later, that all of that be completed within 12 months of adoption of a approval of a program. And a couple of other non-technical things that I'll just mention quickly, unless you want to go through it, Darren. We're proposing a deadline change there. You'll see it says November 1st, 2013. That's for submission of cooperative groundwater monitoring program proposals. Originally those came in last spring. Our goal in making that change is to encourage existing programs to make revisions consistent with this order and to allow groups that may have previously considered or submitted a proposal to resubmit consistent with this order. We're setting a very tight deadline because we do not think we can delay the testing for the drinking water quality any further. And one other thing, and the notice requirements. So we have proposed to revise the notice requirements so that the dischargers or third-party groups provide notice of any exceedances directly within 24 hours to the regional water board. And then the Central Coast Water Board will require the dischargers to provide notice to users within 10 days. If the third-party group, where there's a subtlety there, if the third-party group is actually doing monitoring on wells, drinking water wells that are not on a farm, as part of their characterization and their exceedances in those, then we expect the regional board to provide that notification. We have asked that the Central Coast Water Board work with a number of parties, including the third-party groups, any NGOs, and the State Water Board to prepare a notice, but we have directed that that notice be one uniform notice in English and Spanish that's used consistently. Okay. 70, I think we're done with that. 72, and I'll cover this quickly, and then I'm going to turn it over to Darren again. Page 41. So provision 72 in blue up here, that's simply a deadline clarification. We made this deadline change in the last iteration, but we had put it in the MRP. We had revised the MRP language about the deadline. There's actually, the Central Coast Water Board pointed out that there's a provision in the order itself where we need to make a conforming change. That's what that is. And the next set of edits are in total nitrogen reporting, page 46, and I'm going to have Darren just discuss those.
Sure. So one of the comments was that, I believe from the Central Coast Regional Board, the request that there be added in the basis for what the nitrogen determination, the amount of nitrogen applied was. And so we have added that in. It shows up basically as part of the long paragraph that talks about the total pounds per acre per each crop, and then there's a note in there that says, and list the basis. Our anticipation that this would be a drop-down menu with crop advisor, fertilizer salesman, past experience, my own studies. You know, we'll come up with this really nice long list that's got, basically they can pick. And it would be multiple as well, right? Because it could be a combination of different information sources. For instance, halfway through the season, if your perennial samples say you need nitrogen and they're putting it on, or observation of the crop, or all those kind of things. So we really want to be able to capture that aspect of it. Also, we've added in the nitrogen content of the soil for method 2. So there was a comment that we did not have it there. I still stand by that you do not need it for the calculation as intended, but it does have some additional value potentially to have it. The way we've written it is it would be a once a year. Everybody ought to know kind of where you stand. Our recommendation is that it be kind of between crop plantings or cycles or something like that, so that you can do an annual comparison yearly of it. So we do have that. It's just kind of a check to see whether you're going up or down. It doesn't really factor into the calculation needed on the method 2 as described. And finally, we did not accept the change to make the reporting of the nitrogen in irrigation water a change from concentration to mass. That gets problematic. Certainly mass is what we're ultimately striving to determine is going on. Not all irrigations are easily measured. And I think there's adequate estimations that we can make based on crop type and some other needs associated with once we have the concentration, and they have the concentration that they could use towards that. And I think that's informed a little bit from the CDFA nitrate task force as well, which is looking at that. It's kind of a future area of analysis. And one thing that's actually kind of missing from the whole discussion we've had here, which is that irrigation management is as big, if not a bigger piece of the nitrogen puzzle overall, because, you know, one bad irrigation, you can push it all out and get to start over. So I think that's certainly for future consideration and expert panel guidance on what might be appropriate for us in a regulatory scheme, if anything, in that regard.
I'm going to cover just one other minor change on this. We have proposed to add language both in the discussion, there's a little bit of blue up there, and in the text of the order to clarify our intent that method 2 be used primarily by farms that have multiple management blocks and rotations. Although we are not constraining the use of method 2, we continue to believe that recording and reporting by management blocks will provide better data for both the dischargers themselves and for the regional water board to use. Those are the major changes. We'll scroll through to the end and I'll just go through a few minor things. On pages 52, 53, these are conforming changes. These are the changes made to the nitrogen, total nitrogen provisions, and we're just bringing them into the irrigation and nutrient management plan. Similarly, on pages, I think it's on page 60, and then again on 62, same changes. This is the annual compliance form requirements, and we're just, again, making it consistent with what we did earlier in the order. Page 63. That blue you see there, we had a discussion at the end of the September 10th board meeting and agreed that for the October 1st, 2013 deadline for the submission of the annual compliance form, the form that would be used was the one that was developed after the stay order and not one that would be revised consistent with what we're directing in this order. So that simply memorializes that, puts it in the order. And then page 69, again, these are changes to make this discussion, this is the human right to water discussion, clean water discussion, consistent with edits we've made elsewhere. And similarly, pages 72 and 73, the conclusion have minor changes to make the discussion consistent with what we've done elsewhere in the order. And I think that covers it all. So we can turn to the presentations by the parties. Chair Marcus, do you have that list or do you want me to read it?
Thank you for bringing my monitor on that. All right. Do people know the order already?
I emailed it out, but I can read it out again if you'd like.
Go ahead. And then the coast keepers have asked for a couple extra minutes,
Okay.
which I'm okay with.
Sure. So we're starting with the Central Coast Water Boards, 7 minutes. Ocean Mist Farms, 5 minutes. Grower Shipper, 5 minutes. Farm Bureau, 5 minutes. Jensen Family Farms, 5 minutes. And the keepers, 7 minutes, plus I guess they've requested extra time. The Environmental Justice Panel, 7 minutes. We were proposing to do 3 minutes for other interested persons and then give each party in reverse order an opportunity to speak again for 3 minutes.
Okay. Good. Condensed version of what we did last time.
It's almost exactly half the
things
time.
are, exactly. I think that's the right thing to do. So then first up we have the Central Coast Board.
Good afternoon, Chair Marcus, members of the board. Angela Schroeder, Senior Engineering Geologist at the Central Coast Water Board. We appreciate State Board's time and effort to address the Central Coast Water Board's agricultural order, and we also wanted to thank the stakeholders who are continuing to be part of this, this important discussion. So at this time, our comments focus on one main issue, and that's the timing of implementation. For the last 18 months, we've worked in coordination with growers to implement the order, and it's working. And related to the timing of implementation, we have two primary comments about the timing. The first is related to the submittal of the annual compliance form. So Mel mentioned the edit on page 62 to have this October 2013 version be the state version, and I'll speak to that. And the second is related to the timing for the cooperative groundwater monitoring programs. And Jessica Yara, our attorney, will speak to that. So related to the annual compliance form, on page 62, as Mel mentioned, the clean version of the draft order states that for the October 1, 2013 reporting deadline, growers shall use the existing annual compliance form prepared by the Central Coast Water Board following the stay. Mm-hmm. So Mel said that we agreed to maintain the state version of the form. We disagree with that comment. We intended this to be the interim solution until the board resolved the petition. So it wasn't intended to be the final resolution from our perspective.
That's kind of what I thought you said, so maybe I heard it that way too. So what is it that you would want?
Well, this language is, so essentially we are hoping to extend the deadline for the submittal of the annual compliance form until December 1 of 2013.
Oh, you wanted the
so that we can
December
make the
1.
changes, and let me explain the basis for that. The language is problematic because it results in an unnecessary delay of reporting of the information required by the State Board, and specifically results in a delay of reporting for the nitrate loading risk determination for an additional year until October 1, 2014. So let me play out a little bit the sequence of how it was intended to be used. So the annual compliance form is the main reporting for Tier 2 and Tier 3 farms, and the reporting dates were organized in a specific deliberate sequence to move towards water quality improvement in a sort of methodical, stepwise fashion. And let me explain a specific case related to nitrogen reporting. So step 1, in 2013, all Tier 2 and Tier 3 farms are required to determine their nitrate loading risk and report that determination in the annual compliance form by this October. The state is critical because growers need to know if they are high risk, and the water board needs to be able to provide instruction and assistance to specific growers in order that they can prepare for the nitrogen reporting that's due in October 2014. So then the step 2 is in 2014, Tier 2 and Tier 3 farms that are determined to be high nitrate loading risk begin the reporting of total nitrogen applied. In the next year, the Central Coast Water Board evaluates that first year of data from Tier 2 and Tier 3 farms that are high nitrate loading risk and conducts the appropriate follow-up. So then finally in 2016, the Central Coast Water Board works with specific growers to make iterative improvements to then reduce those discharges of nitrate to groundwater from excessive fertilizer application, and then to document those improvements. The order then expires in March 15th of 2017. So delaying the reporting of the nitrate loading risk determination until 2014 is problematic. Growers don't identify if they're high risk, and we can't provide instruction and assistance in a timely manner.
Angela, can I ask a quick question? So we delayed the nitrate risk factors determination to December 1st. Is it not possible for them to both report the nitrate loading risk and, if they are high risk, also report the total nitrogen applied in 2014?
I would say from experience in our current implementation that there needs to be some prep with the growers in coordination with the water board to make sure that we have the proper record keeping in anticipation of the reporting requirement.
So you need to know ahead of time so you can work with them? So you need to know what their
specific
risk level
growers.
is
That's
so that
correct.
you can work with them between December and October.
Right, to ensure that we're all prepared and are doing the proper record keeping so that we can report it out in October 2014.
Okay, thanks.
So we think that there's a simple fix to remedy the situation, and that is simply to extend the deadline for submitting the next annual compliance form until December 1 of 2013. This has many benefits. The extension gives growers time to prepare. It provides time to the water board to implement the order and make changes to the annual compliance form. And it's also consistent with the action taken by State Board last year to implement the state version on December 1 of 2012. And now I'll let Jessica talk about the cooperative groundwater monitoring programs.
I'm Jessica Yar. I'm with the Office of Chief Counsel. And I'm going to be discussing the changes to the deadlines for the cooperative groundwater monitoring plans. If you extend the deadline for new cooperative groundwater monitoring plans, it will create confusion and delay implementation, and it will result in a delay in drinking water wells being tested. And so we would request that you make a simple change. We understand that there do need to be revisions to pre-approved cooperative groundwater monitoring plans, but instead of allowing new groundwater monitoring plans and also delaying the individual groundwater monitoring, we would ask that on page 34, where the new language is, you say, and the individual groundwater monitoring requirements shall not apply as long as the cooperative groundwater monitoring proposal for that discharges, or sorry,
as long as the previously approved cooperative groundwater monitoring proposal for that discharger's area is, revisions are submitted consistent with this order by November 1st, which would allow any pre-approved cooperative groundwater monitoring plan to make the necessary changes, but also continue the deadlines that have already been approved so that we move forward with this process and we get the data as quickly as possible. And we also ask that the next sentence that begins with, if no cooperative groundwater monitoring proposal, and that continues on to the next page, be stricken. So
Wait, say that again, the next one was?
the next sentence begins with, if no cooperative groundwater monitoring proposal for that discharger's area is submitted, and then it ends with the discharger shall have 1 year to comply. That extends the deadline for individual groundwater monitoring essentially for 1 year. And so we ask that that be stricken.
And the reason for that would be because you're adding another year of delay on top of that for the reporting of individual groundwater monitoring.
Can I ask one other question? So my understanding was that the individual dischargers intending to do cooperative groundwater monitoring had to have notified you already, so that
That's correct, but the edits to the order, from our perspective, suggest that they have now until November 1 to submit new proposals.
Correct, so there may be new areas that would be under a cooperative groundwater monitoring proposal then, and then they would have a choice to figure if they wanted cooperative or groundwater in that area, and then have another year after that to submit the results.
I think I need to map this out. Yeah.
Yeah, I want to make sure I understand too. I can't tell, is it your intention that the deadlines remain consistent with respect to any program that has already applied, but not to make any changes so as to prohibit anyone else from applying?
We would request that the deadline be such that only programs that have already been approved make changes and that no new programs be allowed for this order. And I actually believe that there is approval or support from other stakeholders for this change as well.
I think Ken Harris, the EO, did you make mention of this issue at our last hearing, just in terms of the staff workload? Was that associated with the groundwater cooperative monitoring program? I mean, I seem to recall there was some concern from a staffing standpoint.
Ken Harris, EO, Region 3. I don't recall Board Member Moore. In reading this, the appearance is that you're going to open up the opportunity for new co-ops to form, and the workload implications and the delay that would occur from that are huge. We have 2 approved in the region right now. We understand that they will need to make some conforming changes based on this order, and we're good with that. But we want to ensure that the language is clear, that we're not having to evaluate new proposals for new co-ops.
Good. Thank you for that clarification.
Are there any other questions?
Just a second.
So staff, you got those 2 proposed edits?
We have the proposed edits. I think there's some question for the board members as to whether you want to limit proposals at this point to those that have already been approved and just have those make changes to comply with the new provision, or if you think it's more appropriate to allow either new groups to come forward or groups that were submitted but were denied and allow them an opportunity to revise. I think there are a number of options there.
The issue that's holding me up, I'm inclined to want to allow it, but I still am concerned about this extra year issue.
So
Because again, the highest priority is drinking water.
Right. So the extra year issue, I think that was an inadvertent consequence of the changes we proposed. If the board is inclined to allow new groups to apply that weren't previously approved, I think we can easily fix that concern so that individuals don't get an extra year to start complying. That's once we know which way the board wants to go in terms of allowing new groups to apply,
Okay.
we can propose a fix to that as well.
All right, well, my preference would be that we listen to all of the commenters before we opine. So, think about it.
Thank you very much.
Great, thank you very much. You get a gold medal for timing. All right, next we have Ocean Mist Farms and RC Farms.
Bill Thomas for Ocean Mist and RC. And we appreciate very much the amendments that have gone on before what's relevant today, as well as the most recent changes. We think you've appropriately clarified that 87.5 section and made that relevant to the containment structures. We think that's a good fix of that. Because we intend to individually monitor and report actuals, I'll let others speak to some of the adjustments on the cooperative monitoring, although I think it was a thoughtful fix to use the 50% and the 85% to deal with that. As to the notification of exceedances, we support the clarification that it will be the discharger, which in some places may be the farm operator, other places the landowner, making the notification. That was a clarification. We appreciate that. The 10 days, I think, is very reasonable and satisfactory. We sought that. So we would support, or we could live with, the order as is now crafted. And it's a miles different than where we started, both in the language of the order, the ability to comply, and the relationships that are likely to continue to improve between the discharger community. And that would not have happened but for all the investment that your staff and this board has taken. Now I hope we can turn those same level of efforts towards compliance and towards water quality improvements. Unfortunately, those are often two separate functions, but I think we've done good work here. Because I've conserved so much time, I'll make a irrelevant to this process response to something that Steve, you had said earlier in the day. You had encouraged in a prior item that those that have some influence on the Farm Bill have the Farm Bill pay some appropriate attention to our water quality issues in California. Speaking mostly from the Central Valley because of our involvement in the governor's task force, et cetera, we have been talking with appropriate folks, not just USDA, but in the Capitol and committee members, and we have proposals to try to deal with some of our unserved, disadvantaged communities, right, and getting some Farm Bill monies to that. We've coordinated with the EJ community on that. The Farm Bill, of course, is a passion to those of us in the farming world. We think it's Constitution, Farm Bill, and then other things in law. I would say the access to the Farm Bill is largely through the farm community, and right, we do think that we have electrified America and many other things through the Farm Bill. There is no reason that this Farm Bill can't deal with rural water quality. And as you would have an appreciation, the Farm Bill is a big ticket item with more money than we have to deal with here in California. Thank you for your good work on this order.
Thank you, Mr. Thomas. Grower Shipper Association.
Good afternoon. Tess Dunham with Somax Simmons and Dunn here on Western Growers and the two grower shipper associations. Thank you for your long and involved process on all of this. We do have a couple of comments with respect to the new revised language. First, I'm going to talk about the on the red line strikeout version, page 34, and it is dealing with the Cooperative Groundwater Monitoring Program. In the new language, it says at the very bottom of all the new blue text, drinking water quality information must be reported as it becomes available, and all of the requirements of this paragraph, with the exception of any repeat sampling, must be completed within 12 months of approval of the program. We do have some concerns with the constraint of the 12 months. In that with the new language, you may take a hypothetically already approved program that has an approved schedule by the executive officer that was determined appropriate based upon the size of a program. It now gets truncated with this 12 months and new requirements are added to it. And in fact, with this, not only do you, let's say the program hypothetically was going to do a statistical projection and they have timelines within an approved work plan to submit all of this information. This, as it is written, not only does that have to occur within the 12 months, but so does any follow-up sampling for those projected wells within the 50% range. So you're not just talking the first statistical projection, you're also talking any sampling that then needs to be done of wells within a 12-month program. And you might want to remember that some programs may have been approved prior to this date, and in fact, therefore, 12 months from their program approval would put them not a year from today, but a year from perhaps July or somewhere else. So actually what we would contend is actually we would suggest that the language be where it starts with "and all of the requirements," just all that be deleted. We think that, you know, the executive officers have, you know, they approve these programs. They have the discretion to determine what they think is an appropriate amount of time. They know drinking water is the ultimate concern. They're not going to approve a program that they think is going to delay things. And in fact, you just heard the regional board talking about concerns with any delays. So we do think that discretion should remain with the executive officer, then truncating this, especially as it may apply to an approved program that already has a time frame that has been determined to be appropriate. Is that as hypothetical as I can get it? So that is one of our key issues with the new language going forward, that we would like to see that last part stricken with respect to the 12 months. On the notification issue on the next page, I just did have one, actually it's more of a question than a suggested change, and that is it says the discharger's farm/ranch, and that's then who has to provide the notice. What I'm uncertain of, does this mean if the discharger is the landowner, and in those cases is the one that then has the 10 days to provide notice, or does this mean if the discharger is a lessee, and then they are a tenant, and they have a landowner who may have control over the tenants that they have nothing to do with, do they still then have 10 days? You know, I mean, so to me, it isn't clear if we're talking about only in those situations as to who has the responsibility. So just looking for some clarification there.
So I think we intended discharger to track the definition of discharger in the order, which I
would be
believe is
either or.
landowners and operators. So your concern would be that the operator should not notify, it should be the landowner only?
Well, the operator would notify the regional board, and right, you have the provision that says the regional board notifies any others. The question and concern that I know others have raised is where the operator is a tenant and has a lease, and let's say on the property are people that the landowner has you know, rented out homes to that the operator has nothing to do with, right? So you have the operator notifying a landowner's tenants that they really, you know, they don't have a relationship with. It's, you know, so it's not their tenants, it's not their employees necessarily. And so you have this, you know, odd relationship between tenants and, you know, landowners. So I mean, obviously we know notification needs to happen, just looking to determine, you know, who's the proper, in that instance, is the regional board the proper entity to make notification? I don't know. But it does create some, you know, some odd relationships. And you have leases that basically say, you're the operator, leave my rental properties alone, you know.
I think part of the concern was how easily landowners in that case can be located if they're out of state or the like. So if I understand your proposal, it's that it be the landowner, and if the landowner cannot do it, then the regional board is the appropriate party to.
Well, I think that your language is that in cases where that there is some language in there that talks about the regional board is responsible for notification. So I don't know that it's my proposal. I'm just suggesting that I think that there is some discrepancy here that we need to look at when you're dealing with operators, and when especially if the rental properties have nothing to do with their operation.
Yeah, I remember this discussion from last time,
Yeah.
and the argument was that 24 hours wasn't enough time because of that problem. And I think our thinking was if you had 10 days, you could work it through with the landowner. I think rather than putting a big burden on, unless you want it, on the Central Coast Board to do the notification, we could just say, you have some sort of language that says if you can't,
if feasible or something, I don't know what.
But you would still have to, obviously, you'd have to notify the Central Coast.
Yeah,
24
absolutely.
hours.
That's the 24-hour. We have no problem with that.
But the limit would be, I mean, if you have some lease restriction where you can't talk to the other tenants, that would be a reason to have the Central Coast do it.
Okay.
But I wouldn't make it a blanket thing that where you're the tenant, you never have to, and the regional board always has to, because that just is adding a workload burden on them. And part of the reason for having a uniform form for notification is to make sure the notification is uniform.
I don't think we have a problem with that. The question is, how do we reflect something like that within the language, just to recognize that there are some odd lease arrangements out there.
What would be the amount of time that would be reasonable to contact an owner, a landlord, who lives in Italy?
Well, I mean, I think if the discharger's obligation is to contact the landowner, they can easily contact their landowner, but how the obligation is written is the discharger has the obligation to notify the users of the water. So it's not the notification to the landowner from the operator. That's not the issue. The question is, who then makes sure that these users get notified that the water that they're drinking may be exceeding the MCL? Which is the most important concern.
Bill?
Well, I just wanted to point out the language in the order itself that would go into the Central Coast order doesn't actually impose an obligation on the discharger, which, as Amel said, is the owner and the operator, so it's a joint obligation, but doesn't actually impose that obligation. What it says is that the regional board will require the discharger to provide that notification within 10 days. I believe that the regional board's practice would be to actually send a separate letter to the discharger, again, owner and operator, or perhaps they would just focus on one or the other. But this is all sort of prospective. This isn't actually creating an obligation. This is spelling out so the public understands what will happen next.
So we're saying essentially that the Central Coast is going to have to figure out how to do this.
Precisely.
Okay, and we can work with them to try to make sure that's clear.
I was just trying to lighten his workload, but fine, that's the way.
So going forward, so just a couple of additional comments. I thought the revisions to provision 33, we appreciate them. I do think it's much improved. We appreciate that you've listed provision 33 in the 87.5 iterative process. Still have concerns, but we'll let those go for now. And with respect to the total nitrogen applied, just a couple of very quick comments. I know I'm running out of time here, but on the total nitrogen applied, there's the new requirement with respect to identifying the underlying basis. And I guess, my curiosity, so we'd have this huge drop-down box, but what is the purpose and relevance of the information? How does it get used then, informatively within this process? So I'm just not sure, we have another new requirement and just what its purpose is as we start adding on ornaments to the tree. And then on provision 11, we agree with the staff's interpretation that they had. And lastly, I do want to comment, which I think is really important, based upon the comments that the regional board staff just made on the annual compliance form, and whether it's just an extension to December 1st, 2013 of this year, or whether it's that this annual compliance form that's due on October 1. I will say that based upon the discussion we had at the end of the last board meeting, we notified and advised our members and growers that they should go ahead and fill out this annual compliance form that, you know, that it would remain as is for the following year based upon the conversations that occurred, because I thought that was the understanding that we all had, is that, you know, that for what is due October 1 of 2013 this year, it is basically was in existence with the state provisions, and that anything new that the board adopts would become due and part of the annual compliance form due on October 1, 2014. With that understanding, that's what we have advised growers over the last several weeks. And so anybody with what the regional board is proposing, as I understand it, anybody who's been a good person and has gone out there and filled out their annual compliance form early, or at least gone to the effort to start gathering all the information to get it filled out by the October 1 deadline, they now have to redo all of that information to whatever it's going to change, which would then be due on December 1st. So, you know, we have, based upon the conversation, I think, you know, we made some expectations to our growers, and I think it would be really unfortunate if all of a sudden now it's like, oh no, it was wrong again, sorry. It's, even if you did it now, you have to redo it because now you have a new deadline with new information.
I thought that was for the second compliance period.
No.
Yeah, we'll, it's an issue we're going to have to talk about,
Yes.
but it's perilous to advise your clients based on a conversation before we're done. I would just say, I mean, I heard it that way too, but obviously I didn't hear it.
Well, I mean, what else are you supposed to do? It's you're 2 weeks from October 1, and, you know, people want to know what, I mean, we have big memberships, and we have people calling, and we, you know, we're here because we're the ones that are sitting here before the board, and you know, you gotta, you feel like you gotta tell them something to say, well, we don't know what to tell you, and you've got to hold on for 2 weeks. It's a really tough position for all of us.
Get it.
So, thank you.
Thank you.
Chair Marcus, just
Oh,
a question if I
that'd be
can.
me.
That would be you, yes. So for Tess, you know, the concern that was expressed by the Central Coast Board is that the order has now, and actually I believe has had since June, a December 1, 2013 deadline for the Tier 2 and Tier 3 growers to determine their nitrate loading risk factors.
Okay.
And so
That's the key piece, right?
right, and so I guess my question is, if we were to keep the proposal that the annual compliance form, they just use the same annual compliance form as you advised them, we probably would adopt for October 1, 2013, but we had a separate reporting requirement for the Tier 2 and Tier 3 for the nitrate loading risk factors, still due December 1st. Would that be, do you think, too confusing?
So I think of what you're saying is that whatever was due October 1, 2013 in the annual compliance form remains the same. And then there would basically be an addendum annual compliance form to add in new information on December 1 of 2013.
Well, addendum, or perhaps not even part of the annual compliance form, but a separate